welcome back to Finally Revealed. In this episode, we're joined by Lisa Epps of Spencer Fane Law Firm in Kansas City, Missouri. Hi, Lisa.
Hi, thanks for having me.
Thank you for joining us. We want to answer some questions we've had about single asset bankruptcies and small business bankruptcies. Can you help us with that?
Well, single asset bankruptcies, you don't see as many of them today as you did a few years ago with the financial crisis and the real estate market really suffering. But a single asset case, while it sounds simple in theory that you're dealing with a single asset, typically a single piece of real estate, there have been lots of fights between the debtor who is seeking relief and its bank, its secured lender. And those are the two main parties in a single asset case. And so for you to be able to make Chapter 11 work in a single asset case, you need to have other creditors besides your bank.
Sounds funny. You want lots of people that you owe, not just one.
Because, and again, not to get into the weeds, but these are things that you need to think about if you're going to make a Chapter 11 case successful, is that you have to have one group of your creditors agree to be treated in an impaired way under a plan. Typically in a single asset case, the bank just wants its land back. They filed a foreclosure action. On the eve of foreclosure, you weren't able to make a deal, and so you file for bankruptcy to stop the foreclosure. And so to make the bankruptcy work, you need to have another group of creditors that is willing to work with you to try to get a plan confirmed.
And when you say work with you and then using things like impaired, you need these other creditors to agree to modify your arrangement with them.
Right. I tend to use bankruptcy words that I use in my head all of the time, but no, that's absolutely the case. So for example, if you have a group of, creditors, on a piece of real estate, maintenance people who keep the facility together, lawn people, different things like that. Let's say that they're owed $100,000. If they agree to, perhaps be paid $80,000 and they agree to have that paid over a period of time, perhaps with a little bit of interest, that's what we're talking about with someone that's impaired. On the other hand, a small business case, that's what a single asset case can turn into if the single asset is determined not to be a single asset. A lot of times there has been a lot of litigation in bankruptcy courts about, for example, hotels. Is a hotel a single asset? And the debtor who wants to take advantage of some of the advantages that you get being a single asset case will argue that yes, a hotel is a single asset. Perhaps the bank will argue, no, it's not a single asset because you've got so many other things going on in a hotel. And so a small business case is a recognition by Congress that not all Chapter 11 cases are General Motors, Enron, huge, where you need 50 sets of lawyers and financial advisors and millions of dollars worth of fees, that you need kind of a more modified and tailored and more streamlined process to get you to the end of the line. And that's really what a small business Chapter 11 will be. There are certain debt limits that you can talk to your attorney about, but you're allowed to get a plan filed in a shorter period of time. You don't have as many requirements to provide all of this information to the United States trustee on a monthly basis, and so it can certainly be advantageous if you are able to take advantage of it.
And it'll save you money.
And it'll save you money, and it will save you time.
Okay, so then that brings us to the owner. Usually this affects the owner. So in either of these cases, with a single asset or a small business case, what about the owner who is putting their company into a Chapter 11 to take advantage of these events and options to help the company continue. We're talking here when the company is going to reorganize and continue. What about now their personal guarantee, which usually goes along with any type of business debt?
Right. And this is probably, no matter what size your company, this is probably the number one question and number one issue that people find it difficult to wrap their heads around. Because especially in a small business case, if the company has bank debt, you as the owner will guarantee it. I mean, that's just going to be a requirement of the bank. And if your company goes into bankruptcy, that does not mean that the bank still can't pursue your personal guarantee unless you file for bankruptcy.
Because you are separate from your company.
Right.
And hopefully you've run your business in the way that they are separate and they're not, you and the company are not one and the same.
Right, absolutely. And so we have had cases where prior to a bankruptcy filing, the bank has filed a lawsuit against the company and the guarantors. The company files for bankruptcy. The lawsuit is stopped, stayed with respect to the company, but the bank will continue against the guarantor. Now, a lot of times in those situations, there's room for negotiations where sometimes the bank may agree to hold off on the litigation until the bankruptcy case until everyone figures out what's going on in the bankruptcy case. But that's something that the bank isn't required to do.
Yeah, so they don't have to stop.
They don't have to stop. And as you are moving through the bankruptcy process, even if you are able to get a case confirmed, the bank can still go after you on your guarantee. And so there's really nothing that you can do absent trying to negotiate with the bank to have them stop pursuing the guarantee. Now, and Michelle, I mean, you've done as many of these as I have, where if you've got a good relationship with the bank, then a lot of times if the company, they'll work with you, and if the company is able to, pay the debt on a, monthly basis or whatever you agree to, they'll agree to stop the litigation against the guarantor. But that's nothing that the bankruptcy court can require. So
right, you have to remember in all of the different bankruptcies, the protection for the bankrupt means the party who's the debtor who files the case, and in a business case, it is the business entity. It's not the people.
And one other thing to remember, because of that, a lot of times your lawyer can only be your lawyer for the company or your lawyer for you individually. And so even though you as a small business owner are so intertwined with your company, it seems like it's one and the same. From a legal perspective, they're separate, and your interests as the business owner, because you've got duties to a variety of other, once you're in bankruptcy, a duty to creditors, your view on things can be very different than your view of someone who is personally guaranteeing the debt. And so a good lawyer will tell you, make sure that you understand those distinctions, and if you need separate legal counsel, it's in everyone's best interest, most of all to protect you.
Right, just so that you know what's going to happen, what can happen,
right,
and what you might be expected to do, so that we just want you to be prepared.
And to protect yourself.
Yeah. So I hope this was helpful. I think it was. It's always good to get somebody who really knows what they're talking about to help us. So thanks so much, Lisa.
Thanks, Michelle.
We'll see you next time. If this was helpful to you, give us a like, share it with someone who might need to know this, and subscribe. We'll see you next time. Thank you for watching.